All right. I see both sides. Mr. Lugo, you're on mute, and Ms. Ramirez. You may proceed.
Thank you. Nicole Ramirez for the appellant Garald Kurtz. May it please the court, I would request to reserve 5 minutes for rebuttal, please.
All right, you got it.
Thank you. This Second District Court of Appeal has previously described the small claims court as the people's court. They have said that it has its own rules with less technicalities to promote the greater purpose of justice for all. It is against this backdrop that the plaintiff filed his pro se statement of claim. Certainly a large percentage of cases in the small claims court are handled by self-represented litigants.
Well, what's the burden of proof here? Is it abuse of discretion? Is that what you have to show the trial judge abused its discretion in denying the continuance to allow him to call a witness that would have corroborated authenticated the attachment?
That is correct. It is an abuse of discretion standard with regard to the motion for continuance. We will also be discussing the de novo standard of review with regard to the granting of the directed verdict or involuntary dismissal, since this was not a.
Well, I mean, I guess what it's coming down is the judge has discretion that if you want to put something in evidence, you have to authenticate it if it requires specialized knowledge. We're talking about depreciation and value of a vehicle, and he wasn't able to say it's worth $5,000 less, but he had an attachment saying it was worth $5,000 less. He just bought the new car within hours. It's involved in an accident. He wants to get the depreciated value, correct?
That is correct.
And do you agree that the depreciated value required an expert to prove it? And if so, did the judge have discretion to say, hey, I've already given you one bite at the apple. Your case already got dismissed. It's been reinstated. He didn't say all this, but the record bears it out. I'm not going to do it twice. The other side's objecting. And you got all the other factors, but you don't have the factor of this was unforeseeable. If he's charged with representing himself, he's charged with a certain degree of knowledge of the law. And the other side never said, just bring it in, we allow it because it's the people's court.
That is correct. And certainly when he realized that he could not speak about that appraisal, that is when he asked for the continuance. The problem with the pro se, and of course this is small claims court, is that they don't know what they don't know. And so whether or not it was foreseeable that he would need a continuance, he certainly said he didn't know how to authenticate that appraisal. He did, however, there was a very small testimony that the car had 78 miles when the accident occurred. So that part was actually in evidence. Was an appraisal needed to show that there was diminution of value? Well, whether or not it was abuse of discretion to deny the motion for continuance, there was no mention at all of any prejudice to the other side if they would have allowed the continuance. And
was there evidence in as to the amount of damage sustained by the vehicle, cost of repair, that sort of thing?
There was not evidence allowed in, and that was the need for the continuance. Did the
other side agree? Was it in evidence that they agreed they paid a certain amount as diminishing in value? They agreed it was $1,400, whatever that number was. Was that in evidence?
That was not in evidence either, of course, because the motion for directed verdict was granted before the defense put on any kind of case either. The issue about the abuse of discretion, the appellant argues, comes into play because the whole argument was that the appellant should have known. He said he was not going to get a lawyer and he should have known. But
didn't the judge encourage him and inform him that it would be best if he got a lawyer, if he had somebody represent him at a prior hearing?
The transcript does mention a prior hearing and that there was some discussion of getting a lawyer, but there is no transcript of the prior hearing in. And even though it's the second bite at the apple argument, There is also the argument that at the first trial, the defense was given a continuance based on just the attorney, because the defense was represented by counsel, saying that they weren't ready. And so where it tips
Wasn't there also, didn't the judge also admonish him, make sure that he knew that he would have to be aware of the rules of evidence and how to get his evidence admitted?
My review of the transcript does not show that that was a very stressed argument in the prior. There was some mention that there were prior hearings, that there was talk about
Right, and
getting.
so
an
there
attorney.
was some mention. So the trial judge had previously taken some attempts to make sure that these individuals were aware from a pro se basis of what's going to be required of them. That evidence is alluded to in the record, correct?
That is certainly correct.
And you know, Ms. Ramirez, and I know you started off saying that our court is the people's court, but we also have to keep in mind, and I think for your client's sake and anyone else who's watching, we are all have taken an oath to follow the law. And when Judge Valenti said, what is our review? Abuse of discretion is you have a real high burden. You have to say, and the case law says, that no reasonable judge in the entire state would have come to the same conclusion as what this judge did in this case. You have a real high burden. So I don't want folks, or maybe your client or folks who say, oh, we're supposed to be the people's court, we're supposed to do this. We are bound to follow the law. And that's, you have a real high burden with that.
That is certainly correct. And it is a high burden. Where the appellant argues that it tips it into an abuse of discretion, despite the fact that pro se litigants have to know the rules, and that is certainly recognized, was that the trial judge did not evaluate the correct factors in deciding whether to grant the continuance or not. And that was that it was certainly an injustice to the movant if it was not granted, since it meant that he was very likely to lose the case, which of course is what happened. But there was no discussion whatsoever of any prejudice that would have occurred had it been continued to another day. It was a Zoom trial. So the only discussion that occurred was that essentially he should have known what he was doing. He made his bed, he should lie in it type of argument. And the judge made his decision and denied the motion almost as a sanction. The transcript shows that the judge made his decision very quickly when he perceived a violation of the courtroom decorum, which he had warned the pro se litigant about. And of course, that was made more difficult since it was a Zoom trial as well, referring to the first name, referring to the opposing counsel on a first name basis rather than with a Mr. Title. And when that occurred, the judge seemed to make his ruling very quickly with an abuse of discretion rather than evaluating the factors to grant the abuse of discretion.
I'm curious, Ms. Ramirez, when your client, did your client, when he asked for continuance, did he say, yes, I will, I've reached the witness, and yes, that witness can be present on a specific time, and that the witness would be available and willing to talk? Was that any showing of that made? You made a comment that the court did not specify the reason. Was there anything like that given to the court? Was there any prejudice argument given to the court? Everything that you're arguing now, was that brought to the court's attention below, or is this the first time you're making this on appeal?
Well, it certainly was not brought in that detail below. Of course, it was a pro se litigant. However, there was discussion with the court that the appraisal itself says that that person can appear as a witness. And so
that, and if I may, and I think, Ms. Ramirez, you've done a lot of cases. You know what the requirements are. You know about preservation. And preservation is that if somebody fails to bring in matter up below, we cannot, out of the blue, go down and do that on our own. And then also too, the specific argument about, oh, I could get him. That's far different from the argument that the case law requires. If you're asking us to determine whether it's prejudice or not, first, I think you have it is problematic. That was not brought before the court. And that specific argument was not made. So I just don't want, because your client being pro se, to think, oh, there must be favoritism because I'm not a lawyer. The beauty about our system of justice, we hold everyone to the same level. Everybody's presumed to know the rules. Everybody's presumed to know the law. And so for that, an issue that's not preserved below, it's very difficult to present it for the first time on appeal. And we cannot, based on the rules, we cannot make a determination on things that have not been preserved below. I'm going on because I want to make sure you know that, and I know I'm preaching to the choir, but I want to make sure that your client who was pro se below also understands that as well.
And the point is certainly well taken, Your Honor. And that is the appellant's argument is very similar to that whole same level playing field argument, was that because at the previous trial, a continuance had been granted when the defense asked for it, that is why the appellant felt that he was looking for the same level playing field, that his continuance would be granted. Just to touch briefly on the directed verdict motion as well, that of course is de novo review, and it does require that there be no evidence that could support the claimant's position, which we have certainly talked about, that there was no appraisal admitted as evidence. The only testimony was that there was 78 miles on the car. And another option for the judge would have been to allow the litigant to speak, but disregard any inadmissible evidence, which is generally the presumption anyway. And just based on that 78 miles, it's one of those public general knowledge things that you hear people say, as soon as you drive a car off the lot, it loses its value. Sort of similar with if a car is in an accident, certainly going to lose some value, is kind of a general knowledge thing. Even if the expert report is not admitted, the fact that it had 78 miles was some scant testimony that was provided. The trial judge was not a jury, of course, so could weigh the credibility of the evidence and the weight of the evidence. So just the fact that there was a scant evidence would allow de novo reversal of the directed verdict. And the appellant does argue that no reasonable judge would deny the motion to continue based on the history of the case and the good cause of needing to authenticate information. I've been in a lot of cases where even when there are...
Let me ask you a question. The other side objected. Now you got 3 former trial judges. We might each do something different. Doesn't make any one of us unreasonable. I mean, I probably would have given him a continuance because he's pro se, but there's not, it's hard to believe there's not a single judge in the whole state that would have done what this judge did. The other side's objecting. I don't want to go through this again. I mean, it's a burden on them too. So they're thinking, I think the judge in your case, in this case, said, everyone's been sworn, the evidence is in, we started the trial. I'm not going to give a continuance midway through the trial. And what could the pro se do? He couldn't do anything. He just said, okay, do the best you can. And then he spoke to an attorney. You obviously couldn't get one to begin with. Small claims, almost impossible to get an attorney on a low monetary case. But this is an interesting issue. So I wouldn't want this issue to be deminimized no matter what we did, because to me, this is an important issue, but I don't know that there's enough facts here to support us to give you essentially a redo. That's what you need, right?
That is what the appellant is seeking, Your Honor, for the reasons given, to reverse the directed verdict for the defense and to remand the case for a new trial.
You're at 6 minutes. You want to save 5 or you want to go for another minute?
I can stop there. Thank you.
Okay, thanks. Mr. Lugo?
May it please the court, my name is Ezekiel Lugo and I represent the appellee Kylie Marie Kuykendall. This court should affirm because the trial court did not err when it granted directed verdict because there was not sufficient evidence upon which the plaintiff could have prevailed.
What about the 78 miles? Is that enough to survive a DV?
let me address that, Your Honor. If the court looks at the transcript, that the reference to 78 miles occurs twice, and it's on pages 12 and 13. But that reference was during opening statement. If the court looks at page 12, lines 8 through 10, the judge is telling the plaintiff, is swearing him in. Do you swear to tell the truth? I do. And then lines 12 through 15. All right, Mr. Kurtz, why don't you, since you've been sworn in and everything, if you want to give me an opening statement, why don't you go ahead and tell me what you want to tell me? And that's where the reference to the 78 miles.
So you're
comes in.
saying there was no evidence to support a diminution?
There was no evidence to support the 78 miles. The only evidence that was presented to the judge, he called his first witness, which was his son. There was one question asked. There was an objection. The objection was sustained, and there was no further evidence presented. So really, there was no evidence at all before the judge on which he could deny the motion for directed verdict. And that basically is my argument on the directed verdict, that there really was no evidence to deny that motion or involuntary dismissal.
Go to the, what was this an abuse of discretion? Was this a technicality? Then the judge had an issue with that rules of evidence is not a technicality. You want to get into that?
The evidentiary issue, Your Honor, it is not a technicality. The rules of evidence are substantive rules. Pro se plaintiffs in both civil and criminal court are expected to, if they're going to represent themselves, they're expected to know the rules of procedures and the substantive rules and to comply with those as they're presenting their case. They're not generally afforded preferential treatment when they're presenting their case at trial. And that certainly applied here. And the small claims rule make it clear that the judge is not supposed to help out pro se plaintiffs with their presentation of the case or the substantive law, and they're supposed to remain neutral, not become advocates for either party.
Mr. Lugo, how do you address, because Ms. Ramirez said her client's perception is, all right, the lawyer asked for continuance, got it. I've asked for one, he didn't get it. In terms of a level playing field, how do you respond to that?
Your Honor, the difference between two contexts is that at the prior hearing, there was still a pending motion to dismiss before the judge. And the explanation is that the trial attorney for the defendant expected that motion would be heard. And that's what the hearing was set for. And that's why the continuance was requested and eventually granted. But when that happened, the trial judge made it clear to both parties that the next hearing was going to be the final hearing, that they had to submit witness and exhibit lists ahead of the final hearing. And both parties did that. The plaintiff submitted his exhibit list. The defendant submitted a witness and exhibit list as well. So at this second final hearing, both sides were aware that this was it. This was going to be the trial. And at the beginning of the hearing, the judge made it clear to the plaintiff that he had to comply with the applicable rules. So the situations were different, and the plaintiff still had to make the proper arguments and support those arguments to allow the judge to grant the continuance. And in this case, there is no abuse of discretion because some of the arguments were not preserved. The arguments that were made below were not raised in the initial brief. And even if the court gets past those procedural issues on the merits, the record is not sufficient for this court to find that the trial judge abused his discretion in denying the continuance. And we've explained in the answer brief this, two ways. The initial brief focused on the fact that the continuance was asked to present a witness, the expert who prepared the valuation report. If that's the argument, if that's the issue, then the court needs to look at case law that requires, Florida law requires all parties, whether they're represented or not, when they're making a motion for a continuance because they need to secure the presence of a witness, there are 4 prongs that have to be met. The first one is that the party exercised due diligence in securing the witness's presence. The second is that substantially favorable testimony would be forthcoming. The third one is that the witness was available and willing to testify. And the fourth is that the witness, the party would be prejudiced if the witness is not allowed to be brought in. In this case, no, that argument was not made. There was no evidence presented or even proffered as to any of those factors. The record does not show that there was any sort of subpoena issued to secure the presence of the valuation expert at this particular hearing. So the first prong of whether there was due diligence in securing the witness is not present in the record. The third prong, whether the witness was available and willing to testify, is also not present in this record. The only thing is what opposing counsel referenced, which is the expert report itself contemplated that the witness, if he was going to be called a trial, there would have to be a separate agreement and a separate fee involved for that additional work that the expert would have to do. And there is no evidence that those steps were taken, even though they were foreseeable, and the plaintiff should have known that if he wanted to get the expert ready and present for the Zoom hearing, he had to do that. There's no evidence that he did that because the argument was not made, and the record does not show that the required factors were met. The trial judge did not abuse his discretion when he denied the continuance to the extent that it was based on a request to secure a witness. The other argument that's addressed in the answer brief is the argument that was made to the judge. The focus in the trial court was on the fact that the plaintiff wanted to retain an attorney in the middle of trial after his objection was overruled and after the judge explained to him that the materials were submitted ahead of time because there was a Zoom hearing, and those are the procedures for evidentiary hearings done over Zoom. That did not mean that the documents submitted to the court had been admitted into evidence, which is a different concept. Once the judge explained those things to the plaintiff, that is when the request for the continuance was first made, and it was again focused on the desire to obtain counsel. At that point, the analysis is based mostly on the three general factors that apply whenever there's a request for a continuance made. And those are whether there would be prejudice to the party asking for the continuance if the continuance is not granted, whether the issue causing the continuance was foreseeable and not due to any dilatory tactics. And the third factor is whether there was prejudice or inconvenience to—
Well, the foreseeability portion is what's at dispute. The foreseeability is at dispute. The other side says it wasn't foreseeable. He thought he could just put this document in evidence without authenticating because he didn't know the rules of evidence. So what do you say about that?
Judge Valenti, the foreseeability, and my argument right now is focused on the request to have a continuance to secure counsel. The foreseeability of counsel is that our argument is that it was foreseeable because this case, he had already filed an initial statement of claim. He failed to comply with the court rules. He did not attend a mediation. He did not attend a hearing on an order to show cause. His behavior resulted in that initial statement of claim being dismissed.
Yeah, but there was two bases for the continuance request. The counsel, I understand, and then the document witness.
And the witness, right, Your Honor. And the foreseeability of the witness, and I think I addressed that in my analysis of the other four prongs. But the witness itself wrote in his report that he was only preparing this report, and that did not include any additional work for him having to show up at a hearing or a deposition and to give testimony. That letter should have put the letter itself should have put the plaintiff on notice that he should at least explore with the witness whether he needed to have the witness present.
I mean, it's all coming back to the evidence code on that issue then, which you've explored.
Yes, Your Honor.
Okay.
And going back to the arguments of about the request based on the need to have counsel, our position is that the three factors supported the denial of the motion for continuance. As to whether there would be prejudice to the plaintiff, if the continuance was not granted, we're relying on cases that explain that just because somebody has to represent themselves at a civil proceeding does not mean that that person would be prejudiced or that an injustice would be worked. The court has to look at the entire context. And part of the context is whether the absence of counsel was based on the movement's behavior at all. And the case law makes a distinction between cases where the attorney falls ill or situations where a conflict arises at the last minute. In those sort of situations, the movement did nothing to cause the need for the attorney at the hearing at the time the continuance is requested. But this case is different. In this case, the record reflects, as Judge Stargell mentioned earlier, the judge and the defense counsel both noted on the record that at a prior hearing, there had been a colloquy with the plaintiff about whether he was going to retain counsel or whether he was going to proceed pro se. And that discussion shows that the plaintiff elected to continue his defense pro se. And again, going back to the initial statement of claim, the first case was litigated pro se. The second case was litigated pro se. At some point, the judge intervenes as this colloquy. The plaintiff says, I'm going to continue pro se. Case continues pro se, and the request is only made again when the evidentiary issues arise. So this is not a case where the absence of counsel was not because of the plaintiff's own
Well,
fault.
I mean, you're basically saying there could be other reasons why the plaintiff has a problem down the road. Even if the judge continued it, he might have some other problems with a different witness, and you could argue multiple continuances would be an injustice. And really, the judge said, that's it, we're stopping here. And that's the abuse of discretion issue that we all raised earlier.
That's part of it, Your Honor. And that goes to whether there's prejudice to the opposing party. And the judge and opposing counsel both noted, we already started the trial. We're here. The parties are here. And that was part of the argument and part of what the judge verbalized at one point during the final hearing when he was looking at or deciding whether to grant the continuance. And that leaves the issue of foreseeability and due diligence. And in this case, since the first trial, the first litigation ended in a dismissal because of the plaintiff's inability to understand and comply with the rules that apply, should have put the plaintiff on notice at that point. When he got that first order that's on page 77 of the record, dismissing the original statement of claim, he should have realized that perhaps he needed counsel. He needed to go talk to somebody and try to retain an attorney. The second time when he should have realized that is when the judge had the colloquy at the prior hearing that's discussed by the judge and the defense counsel on the record. Both of those things should have put him on notice that maybe it was not best for him to try to take this on himself, to understand all the rules and try to comply with all the rules. Maybe he needed advice and involvement from a member of the bar. So that shows that it was foreseeable. And going back to the dilatory tactics, there's a pattern here of not complying with the rules and having consequences for that. Going back to, he didn't show up at the initial mediation. He didn't show up at the order to show cause, at the hearing on the order to show cause. And then he didn't make the request, the motion for the continuance until he was in the middle of trial and things had already gone bad for him. So for those reasons, because this is not a case where there was the kind of prejudice that would support a continuance, it was foreseeable, there was a lack of due diligence, and there was some discussion of prejudice to the non-moving party. This record simply does not support a finding that the trial judge abused his discretion in denying the continuance. And for those reasons, the appellee respectfully requests that the court affirm.
All right, thank you. Ms. Ramirez, I said you had 4 minutes left.
Thank you.
See,
Just quickly to address a few of the items raised. This argument was raised below. The argument that the pro se litigant made all along was that he needed an attorney to authenticate. So whether he used the words finding a witness, of course, he did not go through the 4 requirements of a witness, that he had sent a subpoena, all that sort of thing. And of course, the rules of civil procedure did not apply to the small claims. So the issue below was quite clear. It has not changed. Nothing's been raised new on appeal. It was all about the authentication of that appraisal. And also just to point out that there was no case that I could locate that had these same factual matters, of course. And I understand the court's reluctance to issue a type of ruling that would signal to pro se in general that they can do whatever they want. They don't have to follow the rules, and that's certainly not the case. But just like the cases that are cited in the initial brief, they don't have the exact same fact scenario, but they do show that it can be abuse of discretion to not make simple concessions to a pro se litigant to allow them to have their day in court, so to speak.
Ms. Ramirez, you say a simple concession in this situation, and I am sensitive to some things that Judge Kazam pointed out. I was on the Small Claims Rules Committee for a number of years, even chaired it for a period. And there's always this give and take between making sure that people have access and can come in and present their cases, and them also knowing that there's some legal processes that they have to follow. And that's why the small claims rules are different. And you're asking us to find an abuse of discretion for a judge who walked your client through the need for an attorney or why it would be a benefit. And then at some point, didn't your client go through a cost benefit analysis and say, this is only a small claims, $5,000 or so claim that I'm not going to expend money to find out, or even go sit down with an attorney and ask them to give them some, a half an hour or an hour's worth of advice of how do I get my evidence in? So they wouldn't have even had to represent them in the hearing. They could have went and asked somebody for advice, but he did none of that. The judge made a decision. You want us to find an abuse of discretion when all of this was laid out for him in advance, and it wasn't until the end when he realized, oh no, I can't get my evidence in because I didn't properly do my due diligence to find out what needed to be done. Isn't that what you're asking us to do?
It is what the appellant is seeking, Your Honor, certainly to find that that was an abuse of discretion. It is certainly a high burden to overcome. What pushes it over the edge in this case, the appellant argues, is the abrupt ruling without a discussion of the facts, and for the lack of decorum that seemed to cause the decision rather than based on an analysis of the facts. But it certainly shows, just such as in the cases cited, sometimes the rules are not followed exactly, but concessions, as I'm calling them, are made to pro se to be allowed to have their day in court, so to speak.
Ms. Ramirez, I don't mean to interrupt you, but I need to let you know your time has expired. All right, well, I want to thank
you.
both sides as an interesting case. You both did a great job. We're going to sign off.